All rise. The Honorables, the presiding judge, and judges of the Court of Appeals of the State of North Carolina. Oh yes, oh yes, oh yes. The Court of Appeals is now in session. God save the state and this honorable court. Be seated.
Thank you. Good morning and welcome to the Court of Appeals. Your panel this morning, I'm Judge Donna Stroud. To my right, we have Judge Hunter Murphy. To my left, Judge Julie Flood. And we have one case for argument this morning. Looks like y'all are all in place and ready to go. And have you already reserved your time for rebuttal? Yes. 5 minutes? Okay. All right. 5 minutes. Is that what you're prepared? Very good. Then we are ready to proceed.
Good morning. May it please the court. My name is Heidi Williams. I'm here from the North Carolina Department of Justice, and I represent the state in this matter. This case raises questions concerning the scope of a district court's authority to modify bond after a defendant has been found guilty in district court but given notice of appeal for trial de novo in Superior Court. The Superior Court here concluded that the district court, by imposing a $250 cash bond after defendant had given notice of appeal, exceeded its statutory authority, violated defendant's constitutional rights, and that this therefore warranted the dismissal of all the charges that were pending against the defendant. The state submits that the Superior Court's ruling was erroneous and should be reversed for two reasons. First, under NCGS 15A 1431 F1, the district court possessed authority to modify the conditions of defendant's pretrial release, including by imposing a cash bond requiring confinement pending his trial de novo in Superior Court. And second, even assuming the district court violated a state statute or defendant's constitutional rights, the Superior Court here improperly granted the extraordinary remedy of dismissing all the charges after it expressly found repeatedly that defendant was not prejudiced in the preparation of his case for trial. This violated NCGS 15A 954. Turning first to the statutory issue. In 2005, our General Assembly added subsection F1 to NCGS 15A 1431, which provides the district court authority after receiving a defendant's notice of appeal to order any appropriate condition of pretrial release, including confinement in a local confinement facility pending trial de novo in Superior Court. Now, members of the bar of this state have noted that this provision in 15A 1431 appears to conflict with a separate provision in NCGS 15A 534, specifically subsection E1, which provides that at or after a defendant's first appearance in district court, a district court judge may modify a pretrial release order entered by him at any time prior to, in a misdemeanor case tried in district court, the noting of an appeal. So the position has been taken by some members of the bar that 15A 534E1, once a defendant notes an appeal on the record or in writing for trial de novo in Superior Court, the district court judge loses authority to then modify any condition of pretrial release at that point.
Counsel, can you please explain to us what you think noting of appeal means?
So this was an issue that I took note of my brief, mostly just because I was so interested by it, because there was noting of appeal. It's the only place in North Carolina statutory law that I have found where it described the process of asking for an appeal as noting of an appeal versus giving notice of appeal. And I don't know, that issue has never been addressed by any opinion of this court. Just in my research, I posited that perhaps the statement noting of appeal could be construed differently than notice because perhaps it requires some kind of written request for appeal. And again, this court or the state Supreme Court has never addressed that issue. It was just kind of an anomaly that I noticed as I was reading the statute and wondered if the difference in saying noting of appeal versus notice of appeal had some significance, because this is the only time it's requesting the right to appeal is described that way in North Carolina law.
I know you talk about 7A290, I think we talk about different parts, about 10 days after entry of judgment, but it does have this part, if an appeal has been entered and not withdrawn, the clerk shall transfer the case to the district or superior court docket. Is that transferring of the case by the clerk? Is that what could be referred to as noting? I mean, usually, looking back at when these came into play in the early 70s, weren't we physically making dockets, creating dockets, moving things over? There wouldn't have been any other procedure. So should we be reading this E1 in association with 7A290 in this 10-day period? And maybe that's what's being talked about noting an appeal?
Your Honor, I don't know specifically about what procedures were used to transfer an appeal from district court to superior court back in the 70s when these statutes were first taken. I would say it is consistent with the state's position that transference of the case, however that occurs at that 10-day period, at least during that threshold period, the state's position is that the district court should be deemed to have authority to continue acting in the case, considering bond. And, without having thought about that specific question before, Your Honor, that could be, and that could explain perhaps the difference in the language noting versus notice of an appeal in 534.
Well, I think it's the defendant noting the appeal, right?
Noting the appeal, correct.
The defendant's the one who's noting it, not the clerk, right? The clerk, that's a
I guess-
ministerial duty that
My
somebody
review of
else is doing.
E1, to me at least, suggests the noting of an appeal. It does not give anything saying that's the defendant's action or the court's action or the clerk's action. It just is some type of activity that seems to be known, but doesn't say who the actor is.
That's correct, Your Honor. That's my reading also. So E1 states, in a misdemeanor case tried in the district court, the noting of an appeal, and doesn't ascribe that noting to any particular actor.
So, yeah, and I'm just wondering, because I was a district court judge for a while. So during that 10 days, someone has said they're going to appeal, if jurisdiction was immediately lost by the district court, and it hasn't even, of course, the defendant could potentially not decide to proceed with that, and it hasn't gone, who has jurisdiction to do anything? Under the defendant's argument, or under the trial court's order, who has it? Is there just this 10-day period where nobody has the authority to do anything?
Correct, Your Honor. I think that would be kind of an unreasonable reading of the statute. If the superior court doesn't have authority to act until the case has been docketed in superior court, I think that's a valid concern that who is possessing the case at the time of a noting of an appeal if it's not the district court and the case hasn't yet been docketed in superior court. Lending credence to the state's position that 15A 1431 continues to give the district court authority, even after the noting of an appeal, to continue acting in the case. Subsection D of 1431 states that a defendant convicted in district court is not barred from appeal because he or she complies with the district court's judgment, but that notice of appeal under such circumstances must be given in one of two specific ways. The subsection then states that upon receiving that notice of appeal for trial de novo in superior court, and I quote, the district court judge must review the case and fix conditions of pretrial release as appropriate. Now, as the state pointed out in its brief, subsection D doesn't apply to the circumstances before the court here today because it involves defendants who have already satisfied their judgments in one way or another, but certainly the writing in subsection D stating that the district court must determine the conditions of pretrial release even after the noting of appeal would discredit the defense's argument that somehow the district court judge loses authority to act or to modify pretrial release conditions based on solely the noting of the appeal. Defendant further argues in his brief that even assuming the district court had authority to modify bond under 1431, it was required to engage with and abide by the procedural requirements of 15A 534 when imposing that bond. So under 15A 534, when a judge enters an order of pretrial release that essentially does not allow the defendant to be released back into the community in one way or another, so either requiring a secured bond or requiring electronic monitoring at home, under 534, if there's a policy in place in the county or the district where the court is entering that order that the reasons for that decision be put in writing, the judge is required to put the reasons for that decision in writing. Now, in the state's reply brief, the state suggested that, certainly if the trial court was here deriving its authority to act under 15A 534, it would seem to suggest that it didn't go through the proper procedures because it didn't provide any kind of reasons in writing when imposing the $250 cash bond. However, the state's position is that the court was not deriving its authority to act from Section 534, but rather from 1431. And Section 1431 imposes no procedures where the trial court had to state reasons in writing before modifying the pretrial release order. And I think that makes a lot of sense because when we're talking about Section 534, that statute governs pretrial release and bond orders generally, whereas Section 1431 is specific to a district court's authority after a defendant has been found guilty by the district court and has given notice of appeal for trial de novo in superior court. So when the district court judge is acting at that point, having found the defendant guilty, that judge is aware of a wealth of evidence in the case. He or she is aware of the crimes that the defendant has been charged with, and in fact, after assessing the evidence that the state has presented, that district court judge has found that defendant guilty beyond a reasonable doubt. For that reason, the state would submit that it's reasonable to say, well, it makes sense in that context after the defendant has already gone through this host of procedures to be found guilty in district court, that the same onerous requirements from 534 don't necessarily apply to the district court's decision to modify a bond order under 1431 after having found the defendant guilty beyond a reasonable doubt.
Was that 1431 argument made during the hearing below? That interpretation of the statutes that 1431 control? It seemed like a lot of the state's arguments before the trial court were based on this idea of the defendant needing to prove a negative of, that these findings weren't actually made. So was this 1431 nuance actually made before the court, before the trial court?
Your Honor, I'm hesitant to answer that definitively, not, having specifically looked for that specific question in the transcript. I mean, it's certainly true that at the hearing on the motion to dismiss, the interplay between Section 534 and Section 1431 was discussed, and the various provisions of those statutes were addressed in significant detail by both of the parties and with the trial court interacting with them. But whether or not that specific, like the nuanced question you just asked, Your Honor, I don't know. I can't say for certain whether or not that specific, like it was framed in particularly that way. But certainly there was discussion about which statute applies, and the potential conflict between the two statutes was described in detail. If the court has other questions about the statutory issue in the case, I'm happy to address those at the court's will. Otherwise, I will move on to the second issue on appeal, which is the remedy issue that the trial judge reached in this case. So here, the Superior Court judge at the motion to dismiss found both that the district court judge violated state statutory law and also violated defendants' constitutional rights. And the court determined that based on those statutory and constitutional violations, the appropriate remedy for the defendant was dismissal of all charges. So under NCGS 15A 954, specifically subsection 8.4, it states that the court on a motion of the defendant must dismiss the charges stated in a criminal pleading if it determines that the defendant's constitutional rights have been flagrantly violated and there is such irreparable prejudice to the defendant's preparation of his case that there is no remedy but to dismiss the prosecution. So under the plain language of the statute, in order for the extreme remedy of dismissal to be appropriate, the Superior Court had to find both a flagrant violation of the defendant's constitutional right and irreparable prejudice to the defendant's preparation of his case for trial. And here, particularly with regard to that second inquiry, even assuming that there was some constitutional violation, which the state does not concede, but even assuming there was a statutory or constitutional violation, the Superior Court repeatedly and explicitly found, both at the hearing on the motion to dismiss and in its order, that the defendant, by being incarcerated for from the record, it appears that it was approximately a 3-hour period of time before he paid the $250 cash bond and was released. The Superior Court repeatedly found that that did not prejudice the preparation of his case for trial.
Is there anything in 954 or in other portions of the law that would prevent the trial court from dismissing a charge as a discretionary act? Because to me, A seems like if this, then you must dismiss. So does the trial court not have some power to dismiss a case in circumstances other than these 10 statutory circumstances?
Your Honor, I don't believe that it does. Certainly, we don't. It would be unwise for this court to establish a rule where, in the absence of explicit statutory authority, the right to proceed with a criminal case is left to the court's discretion. I mean, that's a prosecutorial function of the district attorney to pursue charges and to continue on those charges. And so, if a member of the judiciary is just going to say, well, we're not going to proceed with this case anymore, the state would submit that it needs to be able to point to some identifiable authority for providing that remedy, and there simply was none here. So
But if the statutes don't provide for a remedy of a constitutional violation that doesn't rise to this level in 4, is a defendant always just without a remedy for a violation of his constitutional rights?
Your Honor, I guess it depends on what you would mean by remedy. So on one hand, right, the state's position is that the appropriate remedy here was not dismissal of the charges, but was rather to file a motion for modification of the pretrial release order with the Superior Court and ask the Superior Court judge to review the district court's modification if the defendant was unhappy with how that order had come out. Whether or not, Your Honor, there should be, the state is not aware that there would be any.
How would that remedy
Well,
provide either a mechanism for a quick release or, to actually remedy the situation defendant was under? I mean, if I asked the marshal to go put you down in the basement for the next 3 hours, I would sure hope you've got a constitutional remedy just because criminal charges get dismissed. I mean, there has to be something for when the state interferes with a person's right to liberty.
Your Honor, so I think my speculation on that question would be that if there were some kind of remedy for, if on appeal by the Superior Court or an appellate court were to look at the district court's bond order and determine, wow, that was an abuse of discretion, you had no reason to impose bond to actually hold this individual, whether or not under those circumstances a defendant could file some kind of civil claim against the state, I don't know. But certainly, this isn't a case. There are everyday judges who are in this kind of pretrial context are balancing interests. They're balancing the safety of society, they're balancing the liberty of the defendant, and they have to make bond decisions. And the state's position is that the district court modifying bond here was no different than any other bond decision that, in that there is potential that courts in imposing bond, other individuals or other members of the judiciary reviewing those orders might say, well, that's not how I would have done it, or that's not the same, maybe that they say that was too harsh of a bond input. And it's not the case that under those circumstances, well, every time a judge, makes an error of law or judgment in imposing bond, that the criminal case just disappears. So the state's position is that there was a remedy for the defendant to pursue being released or having that pretrial condition of his release modified by the Superior Court, but the criminal law doesn't necessarily provide a mechanism, even assuming that the district court did abuse its discretion in imposing bond, which the state does not concede. The criminal law doesn't provide any specific kind of monetary compensation or anything like that I'm aware of.
If 15A just didn't exist at all and this went on to the Superior Court judge without 15A 954A giving this authority, does the trial court not have any inherent discretionary powers to enforce the Constitution?
Your Honor, again, I think whether or not the court has some kind of authority just by virtue of the fact of finding there was a constitutional violation, and again, the state does not concede that there
Right.
was a constitutional
So
violation.
let's assume that
here.
we get to where
But
the defendant was and we disagree with you there, and we're just saying, okay,
Yeah.
was this a proper remedy or not?
So I actually don't know the answer to that question, Judge Murphy. I would posit, though, that even assuming the Superior Court had some kind of inherent authority to assess, a constitutional violation occurred here, and so dismissal of the charges is appropriate. I mean, even when a court on appeal, like this court, were to find, say, a constitutional violation of a defendant's rights at trial, that it's not just a constitutional violation occurred, you're free. There's analysis of, well, what do we do next? And so, perhaps the appropriate thing to do would be to say, well, now we conduct our harmless error analysis, so where a constitutional violation has occurred, typically it would fall to the state to demonstrate that a constitutional violation was harmless beyond a reasonable doubt. And even assuming, just for sake of argument, Judge Murphy, that kind of analysis applied here, again, the Superior Court repeatedly found that the defendant was in no way prejudiced for the preparation of his case at trial.
Right, but that's not the only way somebody can be hurt by state action.
That's true, Your Honor.
Well, I think that kind of brings us back around to the statute that says it has to be a flagrant violation of the constitutional rights and irreparable prejudice to the
Correct.
defendant, which in those circumstances, and obviously we have lots of cases where there are constitutional violations, a motion to suppress, where like maybe there was an unconstitutional search or whatever, and maybe evidence is suppressed, that may or may not mean that the defendant's case goes away.
Correct.
So that's a remedy that, yes, there's a constitutional violation, but that doesn't mean that we're going to just dismiss the case.
Correct, Your Honor. It's almost as if the statute itself in 954 kind of encompasses this constitutional harmless error inquiry that's made, and the statute is kind of codifying, okay, this is how you do the inquiry for these kinds of violations.
How do you get around State versus Thompson, which didn't really seem to walk through this necessary inquiry? Whether rightly or wrongly, I just don't see where that inquiry is there and where the Supreme Court is saying that necessarily was required here. So can you kind of talk to me a little bit about Thompson and, if you're interpreting it differently? I know it does say, explicitly about these facts and, kind of trying to make it a limited holding, but, we could say the same potentially about these facts, where somebody was given a secured bond after all they did was say, I'm going to appeal your decision that I was guilty, and you give me a secured bond for no reason. So kind of tell me why 954 is so restrictive when Thompson seems to disregard that restrictiveness.
Your Honor, the state's position regarding Thompson is essentially that it is an outlier case. And I agree with you in that it seems a little bit squishy, whether or not the specific circumstances in Thompson fully complied with the 2 statutory requirements in 954. However, I think that grayness of the facts in Thompson is why the state Supreme Court repeatedly in the opinion and very clearly said our holding in Thompson is limited to the discrete facts of the case. I think the court, I presume, was faced with this kind of situation where trial courts, these domestic abusers were being incarcerated pending a hearing before a judge, and they had kind of this policy in place where rather than allowing the hearing to move forward in front of the first available judge, they were forcing these defendants to serve the maximum time allowed by the statute, almost as a matter of kind of prematurely punishing them and then only giving them their hearing when it was absolutely required, even if they had the opportunity to provide that due process at a much earlier point in time. And I think just based on those very specific facts, and again, I think another distinguishing feature of Thompson is that Thompson was dealing with defendants in an entirely pretrial context, whereas again here, we have a defendant who was found guilty beyond a reasonable doubt by the district court before it modified the bond order. So for both of those reasons, I think Thompson is distinguishable and not binding on this court under these circumstances. And I think the Supreme Court's admonition to future courts that Thompson was restrained by the facts, the specific facts, and the practice that was being employed by the trial courts at that time should limit its holding only to the specific context that was at issue in Thompson. I will reserve.
Was defendant here subject to an active sentence with his prior record level for these convictions? For the A1 level 2?
Your Honor, my understanding is that his sentence from the district court had been suspended and he was on 12 months of supervised probation at the time of his, the finding of guilt.
Right, but under the Justice Reinvestment Act, we've got, just like felony sentencing, where you have different grids for misdemeanor sentencing. Is this one that would have allowed for an active punishment at all?
Would it have allowed for it? I believe so. I mean, it was 2 A1 misdemeanors and then one, it was simple assault was the other misdemeanor. But I will reserve the remainder of my time for rebuttal.
And I'll give you a couple extra minutes since we had a lot of questions for you.
Thank you.
May it please the court, good morning. I'm Assistant Appellate Defender Nicholas Woomer-Dieters on behalf of the defendant appellee, Frederick Robinson. In the order under review, the Superior Court made multiple factual findings that after Mr. Robinson gave his notice of appeal from district court to Superior Court, the district court imposed a cash bond and failed to make any findings to justify modifying Mr. Robinson's conditions of pretrial release. This is the dispositive feature of this case. As a matter of statutory law and of policy for the Guilford County courts, the district court could only impose a cash bond on Mr. Robinson if it made appropriate findings in writing. District court didn't do this. So its order was entered unlawfully, both as a matter of statutory law and in violation of Mr. Robinson's constitutional rights. The Superior Court concluded that the constitutional violations were flagrant enough to warrant dismissal of Mr. Robinson's charges. Now, the state concedes the factual predicate underlying the statutory violation, and it barely challenges the Superior Court's conclusions that the district court violated Mr. Robinson's constitutional rights. Instead, the state's briefs focus overwhelmingly on the district court's jurisdiction to modify the terms of Mr. Robinson's pretrial release after he gave his notice of appeal. Respectfully, the jurisdictional issue in this case is a red herring. Because even if the district court had the jurisdiction to impose a cash bond on Mr. Robinson, it nevertheless did so in violation of the judicial district policy and the statute. The real disagreement between the parties is remedy, and what I hope to convince the court today is that the Superior Court order should be affirmed because the violations in this case were so flagrant that dismissal of the prosecution was the only real remedy available. On page 2 of its reply brief, the state concedes that the district court did not provide written reasons in its order modifying Mr. Robinson's conditions of pretrial release to impose a cash bond. This is critical, and I would argue dispositive. As a matter of both statutory law and policy in Guilford County, the district court could only impose cash bond as a condition of pretrial release if it made certain written findings. And I'll get to why, but I first want to note that the state actually doesn't challenge any of the district court's findings of fact at all. So if we apply the rule that unchallenged findings of fact are deemed properly supported by the evidence and are binding on appeal, then all of the Superior Court's findings in this case should be deemed binding for the purposes of this appeal.
Let me ask, we, many times in many different situations, obviously appellate courts end up remanding to a trial court to make appropriate findings of fact where they have not made findings of fact that are required by statute or whatever. Why would that not be the sort of obvious remedy in this case? Especially where there was no prejudice to the defendant. If the court had found prejudice to him, you know, I think obviously that might be a different situation.
Well,
Where the court specifically found no prejudice.
by the time this case reaches, you know, again, we've got this issue about how long did it take for the Superior Court to obtain jurisdiction of the case. But by the time it's before the Superior Court, it's for the Superior Court it's before the Superior Court. And the motion that's before the Superior Court is under 954, and it's a motion to dismiss. That's the remedy that's available, and that was kind of the statutory framework that the court was working under.
Why wouldn't a remedy, if you are in this limbo position, not be to file a petition for habeas corpus with the Superior Court or here? Why would that not be a sufficient remedy?
Well, in this case, okay, so let's talk about the actual discrete facts of this case. The court imposes this cash bond. Mr. Robinson is held. Now, the court makes a finding that it's between 2 and 4 hours. At that point, there's no remedy for him. He's already served the time unconstitutionally, and 954 provides the remedy for that, which is dismissal of the case, provided there are flagrant constitutional violations that prejudice his preparation for the case. So filing a habeas corpus petition during those 3 hours, it's just, that's not a practical option. I suppose it's a theoretical option. But after he's out...
Why isn't it a practical option? Let's see, this is coming out of Guilford County. I'm assuming there's always a Superior Court judge sitting in Guilford County every day. I'm here every day. We get habeas petitions. When we get them, they're taken seriously. They're acted on quickly. So I guess I'm struggling to see why that, given the statutory framework is how it is for these type of dismissals for irreparable harm, isn't it kind of built into the statute that your other potential restrictions on liberty are better addressed by a habeas corpus petition?
Possibly, but again, you know, what we're dealing with here, and what our I'm kind of jumping around here, but and what the Supreme Court was dealing with in Thompson are these periods of confinement where we're talking about just a matter of hours. Now, could Mr. Robinson's counsel have filed a habeas corpus petition under the circumstances of this case? I guess in theory that's possible, but again, what we're talking about is just a very limited period of hours, and the court is kind of retroactively in a position where it's being asked to retroactively provide a remedy for that. And under the circumstances of this case, where we have particularly flagrant violations of the Constitution, the remedy that the court imposed, which it was actually required to impose upon the finding of flagrant violations, was dismissal of the charges. A habeas corpus petition doesn't require flagrant constitutional violations. So we are, in some respects, dealing with different standards here as well. But this was the remedy that was available to Mr. Thompson, when the case was in the posture that it was, where he was not being held in custody. So our contention is that the key statute in this case is 15A 534. And under subsection A of that statute, judicial officials are required to impose at least one of 5 conditions of pretrial release, and those conditions are enumerated in this part of the statute. Subsection B sets forth the criteria for the imposition of one of those 5 conditions that are enumerated in subsection A. So here's how subsection B works. Without making any sort of special finding, a judicial official can either release a defendant on a written promise to appear, on an unsecured bond, or into the custody of a person or organization. In this case, the magistrate chose the second option and released Mr. Robinson on an unsecured bond. Subsection B further provides that one of those 3 conditions must be imposed unless the judicial official determines that those conditions will not assure the defendant's appearance, will pose a danger of injury to anyone, or will likely result in the destruction of evidence, subordination of perjury, and so forth. If the judicial official makes any of those determinations, then the more restrictive condition of pretrial release, like cash bond or electronic house arrest, is required. Moreover, and this is the key part, if a highly restrictive condition like cash bond or house arrest is imposed, the judicial official must record the reasons for doing so in writing to the extent provided in the policies or requirements issued by the senior resident superior court judge. This case comes out of Guilford County, and Guilford County had such a policy. That policy is in the record, and it imposed an unambiguous requirement on judicial officials in Guilford County to follow the statutory provisions of 15A 534, subsections A and B. On record page 30, the policy document states that in imposing cash bond or electronic house arrest, the reasons for doing so must, and must is emphasized, be recorded in writing. And that's using a form that was apparently attached to the policy, but the form is actually not in the record. The state concedes that the district court made no written findings or determinations when it imposed the cash bond on Mr. Robinson after he gave his notice of appeal. And so the state's acknowledged that the district court correctly concluded, that the superior court correctly concluded that the district court failed to comply with section 15A 534, and that at a minimum, the district court's imposition of cash bond in this case violated statute and the policy of Guilford County. The Superior Court also concluded that the district court's order imposing cash bond violated Mr. Robinson's constitutional right to be free from unreasonable seizures. One of the unchallenged factual findings is that after the district court imposed a cash bond on Mr. Robinson, he was taken into custody for 2 to 4 hours before a family member posted bond for him. As a result of the district court order, Mr. Robinson was seized. He's not free to go. His movement is restrained, and so this is a seizure of his person. And the Fourth Amendment tolerates only reasonable mistakes of law by government officials. But the statutory requirements of imposing cash bond in this case and the policies of the Guilford County courts are unambiguous. The judicial officials required to make some sort of written finding or specific written findings when cash bond is imposed. And this policy also wasn't new. It was enacted in January 2020, more than 2.5 years before the district court ordered the cash bond in this case. So the statutory violation was also a Fourth Amendment violation. The Superior Court also found that the district court impermissibly infringed and created an impermissible chilling effect on Mr. Robinson's constitutional right to a trial by jury. It's a due process violation to punish someone for exercising a statutory or constitutional right. Now, there's no express determination in the Superior Court's order that the district court intended to punish Mr. Robinson for exercising his right to appeal de novo. But if we look at the findings of fact, the court all but made that determination. At a minimum, the imposition of the bond was wholly arbitrary. But again, there are at least 5 circumstances that indicate that the bond order was imposed in retaliation for Mr. Robinson exercising his right to appeal.
Let's assume that point, and this gets in a little bit to the remedy. When we see that kind of activity by a trial court in sentencing, or where we look at the words used objectively and say, at least it may have been influence of that, whether it's to get back at the defendant for exercising his right, for not liking something about the defendant's activity that's constitutionally protected, whatever it is, our remedy is just remand. It's not vacating the sentences, not vacating the judgment. It's just we're given a new sentencing hearing. So with that in mind, how is the drastic remedy the Superior Court judge entered really allowable either under our structure or just our general review concept?
I mean, I'd say it's allowed under the statute, which is 15A 954A4, which again...
Can you get there without Thompson under the statute?
I think Thompson look, the way that Thompson used the statute and reads the statute, I think is critical to our case. I will just concede that. But I think Thompson is actually helpful and it's useful for understanding how this statute works. And I'm happy to just jump. It sounds like we want to jump.
I do, but I'm only one of the 3, so I'm just talkative this morning.
Okay, let me just do that, and if I have time to go back. But assuming these constitutional violations exist, let's talk remedy. So the state devotes little space in its brief to challenging the Superior Court's conclusions that Mr. Robinson's constitutional rights were flagrantly violated. But it takes issue with the remedy of dismissal. So Mr. Robinson moves for dismissal of his charges under 15A 954A4, which provides that a court on a motion of the defendant must dismiss the charges stated in the criminal pleading if it determines that the defendant's constitutional rights have been flagrantly violated and there is such irreparable prejudice to the defendant's preparation of his case that there is no remedy but to dismiss the prosecution. Now, here are the words that I think, this is where Thompson, I think, comes in, because we're talking about the defendant's preparation of his case. And under Thompson, as Thompson kind of reads and applies the statute, that goes to more than just merely the defendant's preparation of his case for trial. So you'll notice if you read the latter part of Thompson, and it's a long case, but that last maybe quarter of the opinion, when our Supreme Court applies the statute, it doesn't engage in this kind of traditional prejudice analysis where they're saying, well, the defendant didn't have because he was confined, he didn't have access to this witness and this exculpatory evidence, and so on and so forth. Instead, what the Supreme Court found was that, or observed first, is that the defendant in Thompson was held over the weekend for nearly 48 hours because he was charged with 3 offenses, which were each punishable by a minimum of 1 day of imprisonment. The Thompson defendant had already served almost 2/3 of his minimum sentence exposure. Now, unlike the Thompson defendant, Mr. Robinson was tried and convicted in district court, and the district court imposed an intermediate punishment. So all things being equal, had Mr. Thompson accepted the district court's criminal judgment and not entered notice of appeal, he would have walked out of the court without being subject to any confinement whatsoever. It was only when Mr. Robinson exercised his right to appeal that the Superior Court, his appeal to the Superior Court, that he's subject to a period of confinement. Now, going back to Thompson, the second feature of it, which I think is important, is that the Supreme Court observed that the defendant was held for several hours on Monday, even after judges were available to conduct a pretrial release hearing. And so, as with the Thompson defendant, Mr. Robinson was also held unconstitutionally for a period of 2 to 4 hours. And again, you know, the prejudice to the defendant is in that those hours of confinement, and the court is not engaging in some sort of analysis of whether he lost the ability to present evidence at trial or so forth. That's not the harm here. It's the flagrantly unconstitutional confinement that kind of triggers the statute. So here, when you get to the bottom of Thompson, that's when our Supreme Court applies 15A 954 A4, and states that, you know, the circumstances of that case were sufficient to warrant dismissal under the statute. So in this case, we have flagrant violations of clear statutory provisions and judicial district policies, an unreasonable seizure of Mr. Robinson's person, and what appears to be an arbitrary, if not retaliatory, imposition of cash bond, which the Superior Court found created an impermissible chilling effect on Mr. Robinson's constitutional right to trial by jury. So, and again, I want to emphasize that there's no meaningful relief available to him aside from dismissal after he's served this time unconstitutionally. The mechanism that's available, and the state hasn't noted any other one, for him when he's at this stage is he's got dismissal, and I can't think of anything else that the Superior Court was empowered to do. Certainly not any statute comes to mind that the court could have, where the court could have crafted a remedy, you know, other than dismissal. I mean, that's what the statute's provided, and so the Superior Court, you know, ordered the remedy that actually the statute mandates the court to impose upon a finding of a flagrant violation that prejudices the defendant's preparation of his case. Again,
I'm still having trouble in this factual circumstance, figuring out how the few hours there would have, I mean, and obviously the Superior Court found there was no damage or, you know, no prejudice to his ability to prepare his case. I mean, that's what the statute says.
Right.
And I think Thompson, as the Supreme Court said, was to be limited to the discrete facts of that case, which is a very different circumstance.
I think, I mean...
No judge had ever heard, you know, the case against a defendant in Thompson. This judge has heard the case and knows a lot more about the defendant and about the situation and about the crime, obviously, than anyone knew when that bond was initially set.
That's true. In the court, you know, the district court had heard the case, but nevertheless, Mr. Robinson had a statutory right to appeal de novo to Superior Court. And nothing in the statute, certainly not in 15A 534, A or B, states that, you know, this doesn't apply after a district court has adjudicated a defendant and entered a criminal judgment against him. It applies just whenever a condition of pretrial release is imposed.
There should be findings, yes.
And there were no findings in this case. So, I mean, and it's not like, we're talking about check boxes here. I don't know what, we don't know what the form was because that's not in the record. But these are not onerous requirements here. They're kind of like check a box, make a finding. And surely, you know, if there was something that came out at trial that met one of those criteria for imposing a cash bond, there was nothing that prevented the district court from doing that. It was clear from the statute what the district court was required to do. It was abundantly clear based on the policy, which is promulgated by the senior resident Superior Court judge and the chief district court judge of that district. And the policy had been in effect for more than 2.5 years. Everyone knew what was supposed to happen. Mr. Thompson gives his notice of appeal, and he's locked up for a period of 2 to 4 hours under the findings of fact. And there's no way to remedy that situation other than a habeas corpus petition filed immediately at that time to make him whole. And again, if, you know, under 15A 954, if there's when you have flagrant violations of the defendant's constitutional rights, the remedy and prejudice to the defendant's case, you know, not just his preparation for trial, but to the case in the more holistic sense, the court must impose the remedy of dismissal. I just want to go back and go back to point out some of these circumstances under which the cash bond was imposed, because I think that kind of highlights the flagrancy of the violations here. So first of all, we have, as I've harped on, you know, the violation of the statute and the district, the policy for the Guilford County District Court. You know, second, we have the timing. It's only after he gives his notice of appeal that the district court's imposing this condition. Third, we have a finding 7, that the court refused to consider its bond order on defense counsel's request. Fourth, there are no failure to appears in Mr. Robinson's court file. That's finding of fact number 2, and that would obviously be a reason for imposing a cash bond. There's nothing in the file to support that. Fifth, and I forgot to mention this in the brief, but I think it's significant, which is finding number 9, which states that defense counsel conferred with the prosecutor outside the district court's presence, but was unsuccessful in convincing the prosecutor to agree to a consent agreement on bond, not because of legitimate concerns for defendant's failure to appear, but because of the ADA's fear of offending the trial court. So all these findings, along with the district court's violation of the guidelines for imposing cash bond, which are clearly spelled out in the statute and the policy, support the Superior Court's conclusions that the district court violated Mr. Robinson's constitutional right to a jury trial and/or due process. I feel like I've addressed the remedy part, so I'll just skip to the jurisdiction issue really quick. I think the jurisdictional issue would be, this would be a very different case if we didn't have the statutory violation in this case. Then we'd be talking about jurisdiction, and a lot would turn on that. I don't think that's the case. The district court's jurisdiction to impose cash bond was not the basis for the Superior Court's order. And during the hearing on the motion to dismiss, the defense counsel basically acknowledged that the district court had jurisdiction to enter its bond modification. That's at transcript 34. Now, that concession may well have been unwarranted, as now Judge Grein noted in the School of Government blog post that's cited in the state's brief. The apparent contradictions in these various statutes can be resolved by reading 15A 534E to preclude the district court from modifying the conditions of pretrial release as soon as the defendant gives notice of appeal, and then reading the references to the judge in 7A 290 and 15A 1431 subsections E and F1 as indicating the Superior Court judge, following entry of notice of appeal in district court. So there's a theory out there that you can harmonize these things. Again, because so little turns on this, I don't want to dwell on it. But again, even if that reading of the statutes is wrong, and the district court retains jurisdiction to modify conditions of pretrial release for some period after the defendant gives notice of appeal. Nothing in any of the statutes discussed in the state's brief nullifies the criteria for lawfully imposing a cash bond in 15A 534B. In other words, if the district court had jurisdiction to impose a cash bond on Mr. Robinson after he entered his notice of appeal, it was still required to make written findings by statute and Guilford County policy. So regardless of how this court resolves this jurisdictional question, the case turns on the violation of 15A 534. So there's no question that the district court failed to make written findings when it imposed a cash bond on Mr. Robinson. The state concedes it didn't. And this means that the district court order imposing cash bond was entered in violation of the statute and the district policy. In turn, that meant that Mr. Robinson's constitutional rights were violated because he was seized unreasonably. And in the Superior Court's words, there was an impermissible chilling effect on his right to trial by jury. These were flagrant constitutional violations that led to Mr. Robinson's confinement for a period that was much longer than the district court's criminal judgment imposed, which was no confinement at all. Dismissal was the only remedy available to the Superior Court that could meaningfully address the violations of Mr. Robinson's constitutional rights. So the Superior Court order should be affirmed, and if there are no questions, I'll sit down.
If we're reviewing this as a discretionary decision, because there was no irreparable prejudice to the ability to do the trial under the statute, what standard review do we apply of the decision to dismiss as the remedy, if it's not necessarily required by 954 as a must?
The best answer I can give to you off the top of my head is if it's a discretionary, if it's discretionary relief granted by the court, would be an abuse of discretion standard. But again, I feel like, you know, I'd urge the court. Thompson is a long and complicated case, but that last third to quarter of the case kind of really enlightens how our Supreme Court conceived of the statute and how it reads this prejudice aspect of it. And so I don't think this court needs to turn this 954 relief into a discretionary relief. I think just applying the statute the way the Superior Court did and the way our Supreme Court did in Thompson gets us over the line here and justifies affirming the Superior Court's order in this case.
And looking at Thompson, when they allowed the lower remedy of dismissal to stand, they're referencing a lot this, I think it's Armstrong case in the U.S. Supreme Court. Just double check that real quick, make sure I got the right link here. Yes, Armstrong. In the Armstrong case, even the U.S. Supreme Court just remanded and said, you know, things need to wipe the slate clean and start anew. So Armstrong itself, just from what I'm reading, just sent it back down for another trial from the start. But Thompson went on to go forward with dismissal remedy. Is there anything we should read into that or no?
Again, I think that what controls in Thompson, what kind of controls the analysis here is the 15A 954. Once we have flagrant violations, if there's irreparable prejudice to the defendant's preparation of his case, not the trial, but the case, upon that determination, the court must dismiss. That's what the statute says. In terms of Armstrong, I don't know if there's an equivalent federal statute that's at play there, and I'd be happy to brief it if the court like.
And I was just looking at the record, page 18. It looks like the district court order, the district court judgment, looks like this was all consolidated for sentencing together in A1 level 2. So it looks like he was given 150 days, when under an A12, the most he could have been given suspended was 75 days.
Your Honor,
Was that ever raised at the trial court to show any relation of that to
not
ignorance or mistake or inattentiveness or whatever?
Not that I recall. Again, you know, the argument kind of evolves. It kind of starts out as a jurisdictional claim, and then it becomes more of a 954 claim. Candidly, when I was reviewing the record last night, I noticed that myself, that the 150 days was wrong under the misdemeanor sentencing guidelines. But again, I think the important thing is that no confinement at all was imposed, even after the district court heard all this, had the trial and everything else. He could have walked out. And instead, it was only after he says, you know what, I want to exercise my right to appeal de novo to Superior Court, that the district court imposes a cash bond on him, which results in him being confined against his in violation of his constitutional rights, in flagrant violation of his constitutional rights. And the remedy, when he gets to the Superior Court after he's served that time, he has no remedy other than 954A4. And so that was the relief that the Superior Court granted in this case.
All right,
Thank you.
Rebuttal? So I'll give you an extra couple minutes since we have a lot of questions.
Thank you, Your Honor. Just a few points in response. Judge Murphy, I wanted to briefly address your questions to opposing counsel about, well, what were the mechanisms that defendant, if the district court did improperly impose this modified bond order, like what were his mechanisms for relief? Was it habeas corpus? Was it 954? And I just want to direct the court's attention to NCGS 15A538, which provides that a person who is detained or objects to the conditions required for his release, which were imposed or allowed to stand by order of a district court judge, may apply in writing to a superior court judge to modify the order. So under the statute, if the defendant was displeased with the modified order that the district court imposed under 15A538, it appears that he would have had the right immediately to apply with the superior court judge to review that order. Now, what kind of timeline would be involved in that, I don't know, but I would presume that, you know, this is something that a superior court judge could take a look at relatively quickly. So I think that statute provides the way that the defendant should have challenged the district court's modification and did not need to seek review of that by filing this motion to dismiss under 954. Second, I would like to give a little bit of pushback or I guess response to the defendant's argument that the proper remedy here is, the only proper remedy is dismissal of the charges. And this is kind of more of a public policy argument in that the defendant conceded here, his counsel conceded at oral argument that essentially all they needed the district court judge to do to impose the cash bond was to check some boxes. They needed something in writing, and that was only because this was a policy of that specific court. You know, they had enacted these policies where they said, well, if you're going to actually hold someone, we want some reasons in writing. However, the state would just submit that, you know, saying, well, anytime a judge fails to check a box, that the entire criminal case goes away, I think could lead to some really dangerous, could lead to setting some dangerous precedent if that's the requirement. In addition, I wanted to direct the court's attention to the fact that the superior court judge at the motion to dismiss specifically said that these kind of internal procedures for that county and issuing determining bond and issuing these kinds of findings in writing were not always followed. And that was, I'm so sorry, I was printing the transcript this morning and I ran out of ink, but it will be around page 44 of the trial transcript. It was when the superior court judge was issuing its conclusions, where she specifically said, you know, these kind of internal operating policies are not always followed by the judges. So again, to say, well, this internal policy that's specific to this county a box wasn't checked here, and so the entire criminal case goes away. I think that would be a dramatic and dangerous precedent for this court to set. Finally, just briefly, as I see my time is, wrapping up.
We'll be at -208 is when you'll.
Okay, all right, thank you, Your Honor. I just wanted to point out that in Thompson, essentially the argument the defendant is making is that Thompson eliminated the second element of the statutory requirement, right? So you have to prove a flagrant violation of constitutional rights and irreparable prejudice to the preparation of the defendant's case. And it appears that the defendant's argument is basically, well, Thompson eliminated that second inquiry. If there was a flagrant violation of constitutional rights and an individual was detained for any amount of time, that warrants dismissal of the case in its entirety. I would like to direct the court's attention to, however, the fact that in State versus Williams, which is a 2008 case issued by the North Carolina Supreme Court, the citation is 362 NC 628, the Supreme Court, 10 years after Thompson, again addressed the proper interpretation of 954 and specifically stated that a defendant moving to dismiss criminal charges, quote, bears the burden of showing the flagrant constitutional violation and irreparable prejudice to the preparation of his case. So even 10 years after Thompson, our state Supreme Court, looking at the same statute, said, that requirement of showing irreparable prejudice still exists and is still enforceable. So again, Thompson, by its own language, stated that it was limited to the discrete facts of that case. And for all of these reasons, the state would urge this court to reverse the decision of the Superior Court.
Let me ask one more question real quick. On page 18 of your brief, you have this part towards the end, fourth line from the bottom, but a trial by jury was not guaranteed on appeal in Superior Court. I was not following this at all. Can you tell me what you're talking about?
Sure, Your Honor. The defendant said that essentially by, if we view this bond as a penalization of the defendant for asking for trial de novo in Superior Court, that was a flagrant Sixth Amendment violation because it interfered with the defendant's right to a jury trial. I just wanted to point out the fact that when a defendant gives notice of appeal for trial in Superior Court, certainly the defendant can ask for a jury trial and is entitled to one if he or she wants to go before a jury, but under North Carolina law, the defendant also has the option, if they would like, to proceed before a bench trial, even in Superior Court. So for that reason, upon noting of an appeal, it's not necessarily guaranteeing that the defendant is going in front of a jury because they have the option under North Carolina law to choose to go just in front of a judge for a determination of their criminal guilt.
Thank you.
Thank you for your time.
All right. Thank you very much for your arguments. And we will adjourn.
All rise. Court adjourned.
Always nice job.
Yeah, thanks.
Like the Supreme Court when they all come down and shake your hand, it's always like, oh, don't move yet.
Oh, yeah, no, I don't
That's
have
such a
enough
strange
oral
practice.
arguments to wonder. They do it at the Fourth Circuit, too.
That's what they said. They're kind of like adopting it as this.
Yeah, I haven't done enough of that of oral arguments to remember, like, how it was doing it.
Yeah. This is, I don't know. I'm like so skidded because like my last argument was the first time I've had a judge, newbie was just like, stop talking. But now I feel like I'm like skittish. Like I'm talking too long, but they were
No, you
very
didn't-
casual, very nice.
No,
That
this
was
is
good.
like, compared to